Fire Away tackles burning questions and hot topics in Canadian employment law, human resources, and dispute resolution. Hosted by Rudner Law, Fire Away is your go-to source for legal insight on the world of work. So whether you are an employee or an employer, a lawyer or an HR pro, let's ignite the conversation and get into today's episode. Here's your host, employment lawyer, mediator, and founder of Rudner Law, Stuart Rudner.
Welcome to Season 7, Episode 11 of Fire Away. This is our holiday edition, and we are very excited to be bringing you the 12 gifts of employment law, who are actually being brought to you by three very special guests: the ghost of employment law past, the ghost of employment law present, and the ghost of employment law future. And I'm also joined by three non-ghost guests, the first of which should need no introduction. She's often a host of the show, as well as being a partner at Rudner Law, Brittany Taylor. Welcome, Brittany. Second, Alex Minkin, who has also been on the show before and is an associate with Rudner Law. Welcome, Alex. And last but not least, David Gellis, who is also an associate at Rudner Law, making his debut on Fire Away. You know, back when I was young, you knew you made it when you were invited to be a guest on Johnny Carson's show, but I think this is sort of the modern day equivalent. So congratulations, David. All right, so we will get right into this. And our goal here today is to talk a bit about what's happened in the last year or so and what we see coming up in the next year or so, again, through or with the assistance of our three ghost guests and our three non-ghost guests. I'm going to stop saying that now because enunciating it is very difficult. But I will take the first one. So the first few are going to be brought to you by the ghost of employment law past. And frankly, all three ghosts were fighting over this one because it could have applied to past, present, or future. And this is termination clauses being under attack. So this is something we've been talking about, and I've been talking about for years and years and years. And the reality is that we continue to see litigation about the enforceability of termination clauses. And the reason is simple. Courts don't like them because the implications of an enforceable termination clause can be extremely harsh for an individual. You know, at the extreme end of the spectrum, it could be the difference between 8 weeks of termination pay and 24 months of severance pay. So courts often try to find ways to help someone get out of the contract that they signed. And we've seen this battleground taking shape over years and years, with courts finding interesting ways to invalidate clauses. We thought that we saw a tremendous leap forward or backward, depending on which way you look at things from, when we saw the Waxdale case in 2021. But now in 2024, we saw the Dufault case, which really took wording that is, for most of us, completely innocuous, entirely commonplace, essentially says something to the effect of the employer can dismiss you without cause at any time and for any reason, as long as you're provided with your entitlements under the employment standards legislation. This is wording we see every day. And yet one trial judge found that to be offside because it had the potential to breach the act, in particular by saying at any time, when of course there are some times when you can't be dismissed, like as in the form of a reprisal or at the end of a job protected leave. So that case is under appeal. The Court of Appeal actually heard the case about a week ago, but we don't have a decision yet. And frankly, although we're all anxiously awaiting the decision, I think most of us expect the court is going to dodge the question, and because there is a very easy way for them to decide the case without addressing the issue. So we may not have any finality there. The other thing that we're seeing, or the trend, is finding new ways to invalidate termination clauses. So Waxdale used the with cause section to invalidate the entire termination clause. Then we saw cases like Henderson, which looked outside the termination clause at other parts of the contract. And so, for example, looked at a confidentiality clause, which said if you breach confidentiality, you can be let go for cause without any notice or pay, and said, well, because that impacts termination and could potentially breach the Employment Standards Act, the entire termination clause is out. So I predict we're going to see the continuation of that, and perhaps even have courts look outside the contract entirely and look at related documents. For example, if you have an incentive plan and the incentive plan says something like, if you're let go for cause, you won't get any more payments. I can easily see a court looking at that and saying, well, that could potentially breach the Employment Standards Act. So therefore, the termination clause in your contract is now invalid. So we're talking about, as I said, cases past, present, and future, because I think that's likely what we're going to see. But before we go on to the second gift, anybody else want to chime in on termination clauses and what we might expect?
No, I think that was a really good summary, Stuart.
Right. Our non-ghost guests are being remarkably quiet so far, but I suspect that will change. So I will turn it over to David for number two.
You're right, Stuart, that will change. This non-ghost is about to talk about the second gift, how wrongful dismissal damages are still growing. And this is another trend that, or ghost that we could have applied to past, present, or future. But what we've seen in the past year is that notice periods are getting longer, and courts are open to awarding aggravated or punitive damages for employers acting in bad faith in the manner of dismissal. And this is something we've seen is a trend, and it's not something that we expect to stop in the near future. So looking ahead, we do think that this is something that courts will continue to be doing. And in the past year, we've seen some cases where courts have awarded 24 months of notice to employees, which is the quote unquote unofficial cap. But even for short-term employees, we're seeing longer notice periods. I recently saw a case where an employee with just under 1 month of service got 5 months of notice. There's another case where a 3-year employee got 7 months of notice. So these longer notice periods are not restricted to these very long-term employees. It's something that we're seeing across the board. And there was an Ontario Court of Appeal decision that came out this year that I think is pretty interesting, which illustrates this trend that I'm talking about. So this case is, and my apologies to the plaintiff if they're listening, I'm probably going to butcher your name, but it's Karampodic versus Thunder Bay Electronics Limited. And in this case, the plaintiff was a 59-year-old employee with 29 years of service. They were dismissed without cause just hours after returning from medical leave for a back injury. They sued. The court awarded them 24 months and $50,000 in general damages. And on appeal, the Court of Appeal upheld the award. And what's interesting about this case is that with regards to the 50,000 in generals, the Court of Appeal upheld that on the grounds that employees can suffer mental distress for the way they are dismissed without that distress needing to reach the level of a diagnosable injury. So the employee was able to claim those damages without needing to advance any kind of medical evidence. So the court affirmed that some dismissals do cause considerable amounts of distress, but it doesn't have to rise to the level of some sort of diagnosable injury where the plaintiff is producing medical evidence. And so to wrap this up, yeah, that's bad news for employers, but the good news is you can avoid these longer notice periods and these aggravated damages if you use strong employment agreements and you carry out dismissals properly, which we will talk about. And lastly, for employees, as damages continue to grow, I think it's very important to get legal advice if you are dismissed, because what a lot of employees do is they assume that what they're being offered or the way that the employers conduct themselves is appropriate because they just assume that the employer knows better. But a lot of the time that's just wrong. So if you get legal advice, you might find that you are entitled to a lot more that's on the table.
Thanks, David. And you're right. A lot of times they assume the employer knows better, and often they do, but they're making an offer that is to their benefit. And they know that in most cases, the employee is not going to bother getting legal advice and might sign off and leave a whole lot of money on the table. So, now that we're seeing the notice periods getting longer, more compensation, people are leaving even more money on the table if they're not getting proper advice. Brittany, Alex, anything you want to add on that one?
Nothing on
No,
my end.
No, just to say that I think the cases that David highlight really show that this whole idea of 1 month per year of service or 3 weeks per year of service, a formula that I still hear people referencing all the time, is just not reflective of the reality of the situation. So, as David said, it's really important if you're an employee to get legal advice because there may be a lot more that you're entitled to than you're expecting.
Yeah, no, I was going to mention this later, but one of our TikTok videos just seems to take off over the last few days and tons of comments on it, which is awesome. But it just confirms that there are so many myths out there and so many people confidently stating that the law is a month per year or a week per year, or whatever the case is. And of course, they're all wrong. But so many people believe this. It's, again, as David said, critical to get employment advice or advice from an employment lawyer, I should say. All right, Brittany, how about gift number 3?
All right. Well, David mentioned the importance of employment agreements, and I'm going to talk about a very specific requirement for your employment agreements to be enforceable, and that's the requirement of consideration. We've talked about this a few other times on the show, as well as in our blog posts. But consideration is something that is often overlooked, but it's crucial. You can't have an enforceable agreement, including an employment agreement, without valid consideration. And just as a refresher, this is something of value that's flowing between the parties. So for new employees, the consideration is the job itself, right? They're being given the job in exchange for signing the agreement. For existing employees, like in a situation where perhaps you don't have good employment agreements and you want to put new employment agreements in place, you have to be prepared to provide something fresh, right? Something that the employee doesn't already have in order for the agreement to be enforceable. This could be a signing bonus, a raise, more vacation. It's just something that they wouldn't ordinarily receive if they hadn't signed off on the agreement. Now, the case I want to talk about that we saw heard this year by the Ontario Court of Appeal is, and just like David, I'm going to butcher this name, Giacomo Donato, maybe, and Pear Tree Securities Inc. This case was really important because it had the court dealing squarely with the issue of adequacy of consideration. This is a question that we get all the time from employer clients who are trying to update their agreements. The question of, well, how much is enough in order for this agreement to be enforceable? What would be valid consideration in this specific example? So in this case at hand, what was happening is that the employee had signed an employment agreement before they started work. They were then asked to sign a second agreement, a new replacement agreement, just a few months later after they'd already started employment. Now, the second agreement contained a fixed termination clause, like an enforceable termination clause. There were some issues with the first one, some more expansive restrictive covenants, and introduced a couple of changes to the compensation structure that this employee was enjoying. The consideration that was offered was just more vacation time. There was the possibility of there being a signing bonus as well that could have formed consideration, but it wasn't specifically referenced in the contract. So what the employee tried to do is argue overall that the contract was worse for him. So therefore, there wasn't valid consideration for this agreement. His goal here was to get rid of the second termination clause, which would have restricted his entitlements. The Court of Appeal disagreed with this entirely. They said courts are only concerned with the existence of consideration rather than the adequacy of the consideration being provided. It's not the court's job to determine whether the consideration was valuable enough for the new agreement. Now, this is a really, really positive decision for employers, especially employers who are thinking about moving their existing employees onto new contracts. It may not be as expensive or as onerous as you are worried about, considering this latest case from the court. And this is also a really important decision for employees to be aware that courts are not going to be taking into account the overall change in the contract in determining whether consideration is valuable enough. So really, really helpful and interesting decision for employers and something that employees definitely need to be paying attention to.
Yeah, I love the case, although I still have to admit, I expect some courts are still going to look at adequacy if it's just completely imbalanced. So we'll have to see. But I think the only other point I wanted to add is it's true that according to this case, courts aren't concerned about adequacy, but we often get clients saying, as you said, asking us how much is enough. And we always have to remind them it's not what a court says, it's also what is going to be enough for the person to sign. And as we've sometimes said, if you have an employee who won't sign, you could offer them $1 million. If they won't sign, you can't force them to. and you can't force them onto a new contract otherwise. So that's something to bear in mind as well. It's often not a legal question, it's a practical question of what will it take to get this person to sign the new contract. All right, so we are now going to welcome the ghost of employment law present for the next few gifts. And David, I believe you're going to be acting as the conduit for the next one.
That is true, Stuart. I'm the conduit for this next ghost, which is another ghost who could have easily been the ghost of employment law future, but I think it makes sense to talk about it in the present. So I'll be talking about AI and how employers should be proactive about AI. Um, so AI is beginning to be more and more popular in the workplace, and it's already seeing widespread use by employers in hiring and screening processes, and also in chatbots. So if you've been to, let's say, Air Canada's website, you've probably seen the chatbot pop up, and you've probably seen it in other websites. So that's an example of an AI tool that employers have increasingly been using. The issue that makes this a bit of a ghost that can haunt employers is that there's not a lot of law or guidance with respect to the use of AI. We have one decision and one bill in Ontario. So that would be Bill 149, which uh, requires employers to disclose the use of AI in hiring in public job postings, but this bill is not yet in force. And the decision we have is from the British Columbia Civil Resolution Tribunal, and that's Moffat versus Air Canada, where the plaintiff sued Air Canada for their chatbot giving them wrong information. So that's kind of what we're working with. But that doesn't mean that there is no risk or that employers can just act like it's the Wild West. There is actually a lot of risk and liability for using AI. So um, with respect to hiring and screening, AI can actually discriminate against applicants inadvertently, and it can do this in many ways. But a really uh, important one that people are starting to realize is that a lot of the data that AI uses is based on or can be based on biased data that makes it reach discriminatory decisions. And if employers just act on that output without checking first, they might be inadvertently risking liability by making discriminatory hiring decisions. And this is actually something that Amazon had to deal with recently when it kind of had to scrap its AI hiring tool to fix its biased data. And then the other big source of exposure is with chatbots. So as I mentioned, Air Canada was held liable for its chatbot giving a customer wrong information. And that's something that employers should be aware of is that you do have an obligation to make sure that the information your chatbot gives out is correct. And if a customer relies on it and they suffer a loss, then you can be liable for that. So even if there's not a lot of law, it is really important for employers to be proactive. And I think one of the most effective ways to do this is by implementing an AI oversight policy. So basically have a human individual or a committee to oversight of AI. So that could involve things like making sure the output isn't discriminatory or that it doesn't give people wrong information, reviewing the data that it uses to make sure that it's not based on any kind of biased data set and things like that. And I think if you start doing that now, you can be in a good position when the law inevitably catches up to to match what employers are doing in the workplace. So just to recap, there isn't a lot of law, there isn't a lot of guidance, but the risk of liability is out there. So if you implement policies that address these risks, then employers will be in a good place.
Thanks, David. It's a great summary and a really, obviously, a very timely issue, which we're going to see a lot more of. So I'll keep things moving so we can get through all 12 gifts. Brittany, I think you're up for the next one.
Yeah, so actually, this I think ties really nicely into what David was just saying. Because I'm talking about avoiding unlawful discrimination in the hiring process. So just to make sure that we're all on the same page, human rights legislation does protect employees and applicants for employment equally, both employees and applicants are entitled to be free from discrimination in the workplace and in the hiring process. So essentially what this means is that employers cannot discriminate against applicants based on their membership in a protected group. So you can't discriminate based on age, disability, sex, etc. Even if you have a good reason not to hire somebody, if even part of the reason is connected to someone's membership in a protected group, the lack of hiring would be found to be discriminatory. So the onus is on the employer in a situation like this to show that they did not discriminate, that no part of the decision-making process was connected to the applicant's membership in a protected group. So how do you protect yourself? How do you avoid this as an employer? Well, you want to implement good processes and policies, just like David was saying, right? And this includes making sure that your hiring team is trained properly on how to conduct interviews, on how to review applications properly. You want to make sure that nobody's asking specific questions that are going to give you information related to somebody's membership in a protected group. Things like, do you have children? Are you married? Where are you from? Those kinds of questions, though they might seem innocent, are going to give you the kind of information that you don't need to have and that could expose you to this kind of risk. You also want to make sure that you have kind of a standard set of questions or criteria that you're using for all applicants so that you can demonstrate fairness kind of across the board. You also want to be taking notes, right? You want to be documenting the reasons, in particular, if you choose not to hire somebody, if you choose not to go ahead, that you've got those reasons documented, because you're not going to remember a year, 2 years, 3 years from now if there is some type of application or claim relating to discrimination, what your reasoning was for that specific individual. Regarding social media, this is a big one. Now, I don't think anybody's going to suggest that you shouldn't review social media. I think that it can be really helpful as part of the hiring process, but you want to be careful because this is a way for you to learn information about somebody that would disclose their membership in a protected group. So one thing that we often recommend doing is having somebody else do the social media review, somebody who's not the ultimate decision maker, who can then provide information to the decision maker that's only relevant for purposes of the hiring process and not and avoid having any knowledge that's completely unnecessary. Final thing or thought I just want to note about kind of the hiring process and avoiding discrimination is that uh, employers or employees applicants have a right to be free from discrimination. There's a corresponding obligation on employers to provide accommodation during the interview process. Now, this obligation isn't just found in human rights legislation, it also is found in accessibility legislation, like the Accessibility for Ontarians with Disabilities Act, right? So employers need to take these requests seriously. There should never be an outright no to any request for accommodation, whether from an applicant or from an employee. And it's remember that this isn't optional, right? Failure to accommodate can result in significant liability. These requests seriously, respond to them appropriately. If you're not sure how to do that, contact your employment lawyer.
Well said. All right, Alex, I think you're up for the next gift.
Okay, so I'm going to talk about the return to the office, which is a very spooky ghost of employment law present for many employees. And it's an issue that a lot of employees and employers are currently dealing with. We're seeing many employers wanting employees to be in the office more often, either on a full-time basis or through a hybrid arrangement. And we encounter a lot of employees that want to remain working remotely. So from a legal perspective, the default is that the employer is the one that decides the place of work. It's often an express term of the employment contract that employers can change the employee's place of work. So in general, the employer can recall the employee to the office, but the employee may have accrued a right to work remotely. So a clear example of a right to work remotely is going to be one that is expressly written in the contract, but that's fairly rare. Now, at least in theory, this is a right that could be accrued as a result of the party's ongoing conduct. So, for example, if the employee has been working remotely for just a short period of time as a result of an exceptional circumstance, that won't give them the right to continue working remotely indefinitely. But if they have been working remotely for many years, there's a higher likelihood that the employee has accrued that right. Now, again, if there's a written term of the contract allowing the employer to change the place of work, it's going to be harder for the employee to argue that they have the right to continue working remotely. Otherwise, if there if there is no right to work remotely, then the employee can't refuse to return to the office unless, for example, there's an accommodation question. So for example, if the employee has a medical condition that prevents them from going to the office and they make a request for accommodation based on that. Another example is refusing to return to unsafe work. Okay, so there are some situations in which there's a bit of an exception, but the default position is that the employer is the one that can choose the place of work.
Thanks, Alex. And yeah, I think this is just going to be the battleground that continues for a long time. And as people try to figure out what makes sense for the business, but also tries to remind people that, as you said, by default, the employer gets to choose where work takes place, which we never would have even talked about 5 years ago. So it's fascinating to see how things evolve over time. And speaking of time, I'll be mindful of time. So I'll move on to the next one, which Alex, I think you're going to handle as well. And I will apologize because it looks like some unnamed ghost who may have thought they were going to be talking about this topic may have added some extra notes in there, but a different case. So I hope I didn't confuse you.
Sure. So the next gift is the risk of misclassifying workers. So employees and employers should not assume that a worker's status is as written. If a worker is classified as an independent contractor by the terms of the written agreement, the legal relationship could still be that of an employment relationship. And employers could face significant liability for misclassifying workers. So one example of that is overtime pay. If a worker is treated as an employee from the get-go, they could limit the amount of overtime pay. They could limit the overtime worked. In some jurisdictions, such as Ontario, they could enter into an averaging agreement. But if they are not treated as an employee, if they're treated as an independent contractor initially, and it's later determined they were actually an employee, there could be significant liability for overtime pay. Another example is vacation pay. Vacation pay needs to be paid on top of wages. There can't be an agreement that simply says your wages include all vacation pay. So again, if an employee is treated as an employee from the get-go, the vacation pay, the way vacation pay is handled, can be incorporated into the agreement. If they are not treated as an employee from the get-go, if they are treated as an independent contractor, but it is later determined they were actually an employee, again, this can be significant liability on the part of the employer. And possibly the biggest example of all is reasonable notice of termination. In general, an independent contractor is not entitled to this. An employee is. So if an employee is treated as an employee from the outset, there could be a termination clause in the employment contract that limits their entitlement upon dismissal. If a company is just treating the worker as an independent contractor and doesn't make any sort of arrangements for reasonable notice of termination, there could be a big unexpected liability at the end of the worker's employment. Now, for employees, you can't have your cake and eat it too. If you were getting beneficial tax treatment as an independent contractor, it's going to be harder to then claim notice as an employee. So an example of this is the case of Jetkovich and Breeze, which was a case from this year out of BC. And in that one, the judge found that how the relationship is characterized for tax purposes is not necessarily determinative, but it is a key factor to consider in characterizing the relationship. And what the court said is tax treatment provides objective evidence as to how the parties subjectively saw their relationship. I am convinced that a plaintiff should not generally be allowed to obtain the benefits of a contractor relationship for tax purposes and then simply deny that such a relationship exists for employment law purposes. Now, in that case, ultimately, the court found that the worker belonged to an intermediate category of dependent contractor and was therefore entitled to reasonable notice of termination. But this worker would not have been entitled to some of the other protections that are normally afforded to employees. Now, about a month ago, there was another decision out of BC. This was the case of Raven Points Retreats Limited, which was a case out of the BC Employment Standards Tribunal, which actually went the other way. The tribunal upheld a determination that the worker was an employee rather than an independent contractor. And this was done despite the fact that the employee was paid as a contractor. The employee was, they invoiced the employer, they paid GST, there were not source deductions. So even though they were paid as a contractor and treated as a contractor for tax purposes, based on the nature of the job, the determination was made that the worker was an employee, and this included the level of control that the company had on the worker and their role within the organization. So there is a risk for both parties in misclassifying, and the question is not how the parties want the worker to be paid, but the question is what kind of legal relationship is it going to be.
Awesome, thanks. And another one that could have been the ghost of employment law, past, present, or I suspect probably future as well. That's a great summary. And Alex, it looks like you're up for the next gift as well. And it is already 1 o'clock, so I think all of us will try to be a little more succinct for the last couple of gifts before we come to a close.
Okay, I'll try to be brief on this one. The last gift I'm going to be talking about is the trend of employers and employees not treating the employment relationship as a legal relationship. So on the employee side, there are some viral workplace trends on social media, such as quiet quitting or bare minimum Mondays, essentially just doing, the very bare minimum of effort in their job. And employees need to realize, of course, that acting out trends can have legal consequences, and this could mean suspension, this could mean warning, this could mean other discipline, and in the worst case scenario, it could lead to termination, even termination for cause. On the employer side, we see so many examples of employers not taking hiring and firing seriously. For example, thinking or assuming that seasonal employees are just casual, not entitled to notice, dismissing employees without taking a second thought about what they're entitled to, not treating employees as permanent despite not having a contract that says that. So we're seeing this as an unfortunate trend that can cause a lot of liability for employers. Now, if there is a disconnect in the workplace, or if employees are happy, employers can always try to address this disconnect via policies, by taking their obligations seriously, keeping a safe workplace, respecting employment standards, and in many cases providing greater benefits than just the minimum employment standards. And like many other issues in employment law, it always costs a lot less to prevent these problems than to try to fix them afterwards.
Well said, Alex. Thank you. So we're going to transition to our last ghost of the day. So David, you're going to take on the next gift.
All right. Well, I will keep it brief, and I think this next gift summarizes and caps off what we've been discussing up to now. So I'll be talking about HR counsel as Ghostbusters. So as we've been discussing, there are a lot of things in the employment relationship that are points of risk exposure. The good news is that if you're an employer or an employee, if you work with counsel, you can really minimize your exposure to risk and put yourself in a position where you can navigate all these challenges and have a good strategy for approaching employment law issues. So all that to say, I think going forward, it's really important for employers and employees to consult with counsel. For example, for employers, terminations, huge source of risk, really easy to get wrong. So even if you think you're doing a simple dismissal, it's always advisable to get legal advice and do it properly. That way you can avoid um, things like bad faith damages and additional exposure that you don't need. For employees, certain things like requesting accommodation or handling harassment complaints can be difficult to approach, but if you get counsel, you can get a clear picture of what your rights are and your entitlements. Another thing is severance packages. As I said earlier, a lot of employees just assume that what's on the table is fair because the employer knows what they're doing, but a lot of the time they don't. So it's always a great idea to review your severance package with counsel, and it may turn out that you don't have an enforceable termination clause or contract, or that they're lowballing you. So a lot of challenges like these can be addressed and navigated smoothly with counsel, and in that way, we really are the Ghostbusters of past, present, and future.
I love that. We are going to have to start using that more often in our marketing. All right, so we're down to the last couple of gifts. This goes by a lot more quickly than the 12 days that some people do. Brittany, I think you're up next.
Yes, thank you. So I'm not going to spend too much time on this because we've already talked about this a lot. But one thing that that employers can do to help minimize their liability, as David kind of alluded to, is to implement and use employment agreements effectively. Also, implementing and using policies effectively is a great way that employers can govern their workplace, introduce flexibility, and limit their liability. It can significantly reduce costs. It can reduce the need to engage with your Ghostbusters as much as we love hearing from you. And it also ensures that everybody understands the rules and expectations of the workplace, which is really helpful in terms of having a smooth operation. Now, these things are only valuable if they're implemented and used correctly. You can't just set and forget, right? We see a lot of the times an employer has a great policy that they wrote a couple of years ago and then did nothing with it, right? Either didn't introduce it at all, didn't train anybody on it, or did all of the first steps and then just completely forgot it existed. So just remember, if you've got a policy but nobody's following it, including you, you're not following your own policy, it's not going to be worth the paper that it's written on. So you want to make sure that your policies are actually being used, that they're being updated as often as necessary, and same with your employment agreements. I mean, as you can see from what we've talked about today, the law changes frequently, but that's right. Your needs and who you're trying to recruit may change as well. So have your agreements reviewed. We recommend at least once a year to review your policies and contracts. Speak with your employment lawyer to make sure that they're still serving you the way that they should. And for employees, always review with your lawyer before you sign anything, in particular an offer of employment or a new employment agreement. It can have significant impacts on your rights and entitlements, particularly when it comes to reasonable notice at the end of the employment relationship. You always want to keep in mind as an employee that employment agreements are generally designed to protect employers, not employees. So I highly recommend speaking with legal counsel before you sign anything.
Hey, so you did that so efficiently that why don't you take the next one too?
Oh, if you insist. I'll just talk really brief about some of the legislative updates that are coming in the near future. So for some upcoming changes, we do have new job posting requirements that are going to be coming into effect as of January 1st, 2026. That includes the AI disclosure that David had mentioned earlier. So that's going to be coming into effect soon, not super soon, but soon enough, and it will come up quickly, trust me. We also have new informational requirements that employers have to provide to employees. That's coming into effect a little bit sooner. That's July 1st, 2025. Also, new requirements regarding washrooms and keeping records of how often you're cleaning your washrooms under the Occupational Health and Safety Act coming into effect July 1st, 2025, with some additional record keeping requirements that are going to come into effect January 1st, 2026. And we finally have confirmation that the Digital Platform Workers' Rights Act is going to be coming into effect July 1st, 2025. So for gig workers, for employers who work with gig workers, new obligations are going to be coming into effect next year. More changes are coming. The Ontario government just recently introduced the Working for Workers 6 Act 2024. That was introduced November 27th, 2024. If passed, this is again going to introduce additional amendments to the Employment Standards Act, the Occupational Health and Safety Act, and the Workplace Safety and Insurance Act, including potentially a new unpaid long-term illness leave for employees of up to 27 weeks. So this is not going to slow down. I think we're going to continue to expect to see more Working for Workers acts as time goes on. So stay tuned to our blog. Reach out if you have any questions, but more changes are coming.
Yeah, thanks. And that's a great segue. I was going to say that a lot of the topics we're covering are covered in a lot more detail on our blogs and social media and elsewhere. So you a tremendous gift, and I have a vested interest here. I am, part of my practice is acting as a mediator and arbitrator, but in the context of employment law in particular, mediation can be tremendously effective in resolving disputes that can't be resolved between the parties or their counsel. So mediation is something that should always be considered before proceeding with litigation. The other thing I was going to mention briefly is arbitration, which for whatever reason has not really found its way into employment law in any normal or routine way. And yet at the same time, we all complain about the litigation process. We all complain it takes too long, it's too inefficient, it's too expensive, it's unpredictable. And yet arbitration provides you with an alternative process where you can choose your process, you can choose your judge, you can design it to be as efficient as possible for the specific case, as opposed to the one-size-fits-all approach that, of course, our civil procedure uses, and yet no one uses it. So I really encourage everyone to consider arbitration when you have an employment dispute, whether it's wrongful dismissal or otherwise. The other benefit, of course, is private. So if you're concerned about having the facts of the case become public, if you're concerned about setting a bad precedent, you can have a decision, but it will be private and not create a precedent, especially when you're dealing with things like bonus and interpretation of bonus plans, for example. So consider arbitration, and also consider arbitrate with some limited exceptions. So consider that, and consider that implementing that into your employment contracts, so you don't have to try to see if everyone will agree later on. So that's a 12th gift. So I'm happy we got through all 12 of those. Before we wrap up the episode, I will take my last chance of 2024 to fire away. So for this last rant of 2024, I just want to pick up on a point we've made over and over again, particularly in season 7, episode 11, our holiday episode of Fire Away, which is that if you think you might need an employment lawyer, you probably do. Or as David said in that episode, if you think you might need a Ghostbuster, you probably do. And I love that, by the way. So thank you, David. So looking ahead to what we expect to see in 2024, I've been practicing now in 2025, it'll be 26 years I've been practicing law, and employment law in particular. And every single year I've been saying, if you would think that by now employment law would be settled, but it's not. The law continues to evolve. The societal reality and circumstances continue to change, in particular the last 5 years, but everything continues to evolve, and the pendulum between protecting employers and protecting employees continues to go back and forth. So we don't know what's going to happen. We expect that we're going to see some more battles over termination clauses. And so far, the trend in the last few years is definitely on the employee side of things. So we're definitely going to see that. We're going to see, I expect, courts continue to find new and novel ways to invalidate those termination clauses, including looking at other documents, which gets back to one of the points we always make, which is it's one thing to update your contract, but you should be taking a holistic approach, reviewing your policies, your procedures, and any document that could potentially be used against you. As we talked about, we continue to see new legislation. We've seen the Working for Workers 6 Act. I'm going to predict we're going to see Working for Workers 7. We're going to see the increased use of AI, and people are struggling to deal with the practical and the legal implications of that. And we'll see some more legislation to address that. We're going to see more legislation in case law dealing with gig workers. We're going to see continued fights over where people are working, which has not slowed down at all. We're going to see damages, as I suspect, damages awards continue to be increasing. So there's more and more potential liability for employers. And we're going to continue to see people forget that their employment relationships are legal relationships. And we're going to continue to see individuals sign off on employment contracts or sign off on severance packages without getting employment law advice, and often leaving a lot of money on the table. And we're also going to see employers who are going to continue to DIY their contracts and their dismissals and end up paying a lot more to fix the errors they make rather than prevent them. That's probably not going to change, although we can hope. And I will mention really briefly that we've been pretty active on TikTok this year. I've been having fun with that. And just over the last few days, one of our posts seems to have taken off, about 20,000 views and a lot of comments, which is awesome. But most of those comments contain information that is wrong. So it just confirms what we always say. There are so many myths and misconceptions out there, and everyone is confident that what they're saying is right. So if you're going to make a decision, whether you're an employee or an employer, don't rely on assumptions, don't rely on your friends, don't rely on your Google search. Get the advice you need from your Ghostbuster or your employment lawyer, because if you think you might need an employment lawyer, you probably do. So our wish for this year is that people will start calling us before they make decisions that are going to impact their rights or their potential liability. And that's all for my rant for this month and for 2024. That's also a wrap on season 7, episode 11, our holiday episode of Fire Away. So I'd want to thank, first of all, Brittany, Alex, and David for joining me, along with the ghosts of employment law past, present, and future. Our next episode is going to be January 21st with Pamela McElvain talking about diversity in the hiring process. So I encourage you to join us for that. I want to thank everyone for tuning in today and also for tuning in and watching us throughout the year. And in particular, I want to thank Rob, Rebecca, and Mark for making sure the show goes off flawlessly as always. And any flaws are mine and not theirs. From all of us at Rudner Law, I want to wish all of you a very happy and healthy holiday season and all the best for 2025. And as always, to quote one of my favorite hockey broadcasters, the pleasure was all ours.
At Rudner Law, we want people to treat their employment relationships as legal relationships and make informed decisions rather than assumptions. Keep up to date on Canadian employment law issues by following us on Twitter, Instagram, LinkedIn, and TikTok, liking our Facebook page, subscribing to our YouTube channel, and signing up for our newsletter. Past episodes can be found on YouTube, on our website, and archived on Facebook. And if you like our page or subscribe to our channel, you will receive notifications when the episodes are live. As we always say, none of that replaces legal advice tailored to your specific circumstances. If you think you might need an employment lawyer, you probably do. So please don't hesitate to reach out to us.